H-2A, meals, housing, and transportation. Let's get into it. So meals, H-2A employers are required to either provide their workers with 3 meals a day or clean and convenient kitchen facilities. So as a general matter, if you can, we have found it to be much more cost effective for our clients to actually provide a kitchen as opposed to meals. Meals become very expensive. There is a deduction that you can take from your workers' paychecks if you do provide meals, but even then it doesn't offset the cost of the meals, especially because the cost, generally this occurs whenever the workers are also staying in motels, which also tend to be more expensive. So as a rule of thumb, whenever you can, provide a kitchen so that your workers can prepare their own meals. But let's hit this first bullet point. If I'm providing 3 meals a day, do I have to do that on days where the workers are not working? This is a really common question because a lot of times they think, the guys can just go get their own food and they're not working today anyways. But you are required to, even on days where workers are not working. The way the Department of Labor sees it is, well, they still got to eat on those days. And so you're still responsible for their meals. How do I know if I need to provide meals for my workers? Well, so there's 2 things to check. One is your job order. So on your ETA 790, did you say that you were going to provide 3 meals a day, or did you say that you were going to provide clean and convenient kitchen facilities? If it said free and convenient kitchen facilities, then you don't have to provide meals because you're providing the kitchen facilities for the workers to prepare their own meals. Now, this has happened before. Let's say hypothetically, you provide free and convenient kitchen facilities, and then for whatever reason, your workers, your housing becomes unavailable. So let's just say you provide a house and the house has a fire, smoke damage, workers got to get out of the house while they repair the house, and you got to put them in a motel. Well, the kitchen facility is no longer available for them, so you do have to provide meals during that time. So then this next question comes up all the time as people are trying to make the preparation of meals more cost effective. Can I have meals prepared on the work site? The answer is yes. So normally the states actually require that the person cooking the meals is licensed to do so. So they're an actual restaurant or otherwise, but that doesn't keep a restaurant or say a food truck or trailer from preparing your meals on your work site, which does become a pretty cost-effective way to do it. What's required for a kitchen facility? So there's a number of things that are required, and it's just subject to the OSHA standards, or if the housing was built, I think it was pre-84, maybe something like that, then it would be the MSPA standards. But as a general rule of thumb, you can use the OSHA standards because that's the vast majority of housing that workers tend to stay in. And it requires things like you have to have utensils for everyone. So you can't have 3 sets of utensils for 12 people. You have to have utensils for everyone. You have to have pots and pans for them to cook in, bowls, a bowl for everyone, plates for everyone, cups for everyone. There has to be at least 1 stove top for every 10 workers, those sorts of things. And I do have a OSHA housing inspection checklist. I'd be happy to send it to everyone afterwards. So the types of housing, so you can provide hotels, and the standards and the inspection procedures do vary a bit by state. And this can become pretty frustrating because you do have to work with the hotel. So you have to get a hotel that's willing to share some information with you. So like a license and occupancy permit. I've had it a number of times where an employer will they'll rent rooms from a motel, and the motel just refuses to provide their license or occupancy permit because they think it's some sort of trap or something. I don't know. They get all worried about it. But so you do have to have a hotel that's willing to provide that to you, or at least one where you can see that it's visible, which sometimes they do hang them up on in a frame behind the desk or something like that, so you can just get a picture of it. You do have to get a motel agreement. So basically the agreement says that the employer is getting this many rooms from the motel. There's this many beds in each room, that sort of thing. And so you'll have to do that with the motel. So again, you have to have a motel that's willing to sign that agreement with you. So can the kitchen be a common area, or is it needed in each room? It can be a common area. The kitchen's not required to be in each individual room, but it does have to be an actual kitchen. So you can't just have like a mini fridge and a microwave and say, that's one heck of a kitchen. That wouldn't fly by the Department of Labor standards. So you would actually have to have a real kitchen, but it could be in a common area where the workers all meet up. I've seen that a lot. The employer rents out a whole motel and then they dedicate this cooking area for the workers where the workers can all go eat, but it still would have to meet the requirements for a kitchen facility. Catering contracts and what's required. So the meals, whenever you get catering contracts, you have to get catering contracts for breakfast, lunch, and dinner, unless, for example, breakfast is provided at the motel. Then you could just get one for lunch and dinner and say, hey, my breakfast is provided. It's provided by the hotel. That's totally fine. The meals do have to have sufficient nutritional content. It's kind of an ambiguous term, but that's just to say you can't just give them bread every day. They do expect them to have a full nutritional intake. So, and then can I choose just any hotel? No, you can't, because it has to be within reasonable commuting distance of the work site. Two, you have to have a hotel that's willing to work with you on all these other things. And again, just as a general rule of thumb, where it is possible, I would avoid hotel rooms because they are just significantly more expensive. Of course, it's not always possible. There's not always a place that you can rent. Sometimes you got work that you need to get to. So there's a lot of times where hotels are the only option, or maybe let's say that you're only going to be working somewhere for 3 weeks, and it doesn't make sense to rent an apartment for a year for that purpose. So just kind of depends. But okay, let's talk about housing. So fixed housing, which is what I generally prefer, which is what is inspected by the state workforce agency annually. This is where people generally have the best ROI on their applications because the housing becomes significantly less expensive. The questions always come up, well, what's required of that housing? And again, I can send the checklist afterwards, but let's talk about this. Do I have to have a certain number of rooms and bathrooms per worker? The number of rooms is not dictated by the number of rooms. It's dictated by the number of square feet per person in the bedrooms. The bathrooms, you do have to have one bathroom for every 12 people, I believe. But with regards to the room is based off of the square footage. So if you're under the OSHA standards, you have to have at least 50 square foot per person in the bedrooms. So it's not about the number of rooms, it's about the size of the room and number of people within the room. The housing inspection process. So the way it works is once your attorney, agent, or yourself files your ETA 790, the state workforce agency will reach out to the employer to schedule the housing inspection. And they will have a housing inspector come out, or some states are still doing the whole COVID virtual thing. But they'll conduct the housing inspection. They'll go through their checklist. If there's any deficiencies, they'll request those deficiencies from the employer. And under the regulations, this needs to be done at least 32 days prior to the start date of the application. So if your start date on your application is March 15th, all housing things need to be done no later than February 13th, technically. Department of Labor hasn't actually been denying applications on that basis, but that is a regulatory requirement. So if you can push the state workforce agencies to get your housing approved prior to that 32-day mark, it'll also help ensure that your application continues to move along according to the necessary timeline to have your workers arrive by the date of need. Can I use a house I already have? Of course. Yeah. So a lot of people, the way that it works is they'll use housing, the same housing year after year after year. And one cool thing in some states like Iowa, which, a lot of our clients are in Iowa, and we really love working with that state workforce agency because they are proactive and thoughtful. Um, Sometimes you can even have your housing pre-inspected prior to the filing of your application. So say your workers aren't here in January and you want to go ahead and knock out your housing inspection, sometimes the state workforce agency will work with you on that to get that housing inspection. So it's not something you even have to worry about during the application process. So that's a really cool thing, and it makes your application just fly through, because housing inspections tend to be one of the things that hold up applications the longest. Does the housing location matter? Yes, the housing location matters for several reasons. One, it has to be within normal commuting distance of the work sites. So you can't have housing in Iowa and have all of your work sites in South Dakota, because the commuting distance would be, well, I guess technically you could, but you couldn't have your housing location in one area and then all of your work sites 4 hours away, because it's not within reasonable commuting distance each day. There's also other OSHA standards. For example, the OSHA standards require housing that is to be a certain distance from any area where livestock's kept. I think it's 200 feet, something like that. Again, that's on the checklist, so that would be something that you can check. But and then with apartments, how many apartment rooms do I need to get? This is a question that comes up all the time, particularly with first-time applicants. Does every worker need their own room? The answer, again, is no. It's not about the number of rooms. It's about the size of the bedrooms and the size of the house as a whole. It just needs to be consistent with the OSHA regulations, which, as a general rule, if you want to figure out how many people can fit in a particular room, they need 50 square foot of housing space per room. One thing that I have certainly seen this year is that the state workforce agencies, particularly in the Midwest, who are they're subbing out a lot of their housing inspections to just independent contractors. They are being very strict with these rules. You're talking about, let's say you have a room that's 8 inches off of accommodating the people that you need. They'll make you tear out a wall or otherwise. So be sure to have enough square footage per person, and because otherwise it'll reduce the number of people on your petition, or you'll have to find additional housing, which will delay your application. Can I require workers to help pay for bills? So for bills such as your one, generally no. Okay, with electric bills, water bills, those sorts of things, your workers should not be paying for those. Employers are required under the H-2A regulations to provide housing at no cost to the workers. Do I need to provide a lease agreement? Oftentimes, the state workforce agency will require it. Sometimes they don't. Oftentimes they don't, but some state workforce agencies do. So be prepared to provide a lease agreement in the event that you need to. Okay. What if after certification, I want to change housing? This one comes up pretty regularly, and this is in 20 CFR 655-122. So if you are looking for it, this is in there. And you would look for housing that becomes unavailable. Now, historically, prior to last year, they kind of didn't really enforce the whole through no fault of the employer portion. So you have to demonstrate that the housing is unavailable and that it is unavailable through no fault of the employer. DOL prior to last year didn't really strictly enforce that provision. Now they started to. So whenever you are, or maybe it's 2 years ago, but regardless, whenever you are trying to move housing from one housing location to another, it can't be, well, I was in this hotel and it was more expensive than that hotel, so I want to move them. It needs to be something more of like, I was in this hotel and then it had a pest infestation, so I had to move to this hotel. Or I had this apartment, but due to some fire or damage or whatever, we have to move to this apartment. And the procedure for that is you have to submit the reason, the rationale to the Department of Labor. Department of Labor generally approves it pretty quickly if they're going to approve it, or they deny it pretty quickly if they're going to deny it. And once that approval occurs, you can get the other housing inspected by the state workforce agency. Can I deduct the cost of housing? Nope, you cannot deduct the cost of housing from the workers. That's very specific in the H-2A regulations and a very important provision. The cost of housing lies solely on the employer. Can I deduct for damage to the housing? This one depends. This is a reason that your job order, your ETA 790, is extremely important. Because if your ETA 790 does not specifically say that you can deduct for damage to housing caused by negligence or otherwise, then you can't deduct the cost of housing. Deductions for H-2A workers need to be reasonable and lawful. Those are the two types of deductions, or two rationales for deductions under the H-2A regs. So reasonable, meaning you can't deduct more than the actual needed deduction. So worker broke out a window in my house and it actually cost me $200 to get fixed, but it was a big pain in my butt to get a vendor out there to get it fixed. And so I charged him $500 just because he made me mad. That would be an unreasonable deduction, even if that is a lawful deduction because it was disclosed on the job order. Let's say that worker broke out window in my in my apartment, and I charged $200 to him, and the cost of replacement was in fact $200, but it wasn't disclosed on my job order. Well, that would be a reasonable deduction, but it would be an unlawful deduction because it wasn't disclosed on your job order. So you need both of them. You need it to be disclosed on your job order, and then you need to deduct the costs that you actually incur for the damage from the responsible party. So you can't also just say, yeah, they were all in this room, I don't know who it was, I'm going to just deduct from all of them. You need to find out who it was. Can I deduct electric or water bills? Nope. Do not do that. You will get yourself in a whole mess of trouble with the Department of Labor. Can I charge a deposit and give it back to them if they damage the housing? Nope. It specifically mentions in the H-2A regulations that you cannot deduct or charge a deposit for housing or otherwise to the workers. So when in doubt, don't charge your H-2 workers for anything until you get approval from your attorney. Do I need to have and also your attorney should advise you on how to properly document it. So if the Department of Labor did come asking about it, which if you're in an H-2A audit and they see that you deducted from your workers' paychecks, they will ask you about it. It is not a maybe they'll ask you about it, they will ask you about it. So be sure to have it well documented as well. Do I need to have my housing before I start my application? Yes, that's one of the first things that you have to, that's on the ETA 790, the first thing that you file. It requires your housing location and all your work site locations as well. So you need to get the housing arranged prior to initiating the application. Can I choose any location for my housing? Again, no. It's subject to several rules. One is subject to OSHA rules if they're working near livestock. It's also subject to area of intended employment rules that needs to be within reasonable commuting distance. How do I get my housing approved by the state workforce agency? Normally the state workforce agency will come out and inspect it. Sub-state workforce agencies aren't doing that right now. I think most of them are, though, that the vast majority of them actually are physically going out and inspecting housing. They send inspectors out to do it. They go through their little checklist. If there's any deficiencies, you can usually send pictures of the deficiency being remedied to the inspector, and then they'll approve the housing. If you don't get your housing approved by the state workforce agency, it will delay your application. So, and unfortunately, this is the one area where they don't allow the person filing your application to help you at all. The state workforce agencies, in fact, have historically refused to even give us the inspector's information. So this is the one part of the application that falls squarely on the employer, and it's the thing that also causes a lot of delays. So be proactive, make sure that your housing actually meets the appropriate requirements based off of the OSHA checklist that I'm happy to send over. And then if your state workforce agency asks for any remedies, be sure to remedy it as soon as possible. What if the housing becomes unavailable? That one I talked about on the last slide. Sorry, jumped ahead a little bit. Does the number of workers I have affect how many vehicles I need to train? Oh, now we're moving on to transportation. So employers under H-2A regulations are required to provide housing, meals, transportation. So we're talking about transportation now. Does the number of workers I have affect how many vehicles I need to transport from job sites? Yes. So the way that you can think about transportation is I need a lawful driver for each vehicle, and I need one seat per H-2A worker. So if I have 20 workers and the only thing I have to drive these people around are 15 passenger vans, I need two 15 passenger vans because that's what it would require to transport all the workers. If I have 45 workers and my H-2A drivers, or my drivers are H-2A workers, meaning they can occupy one of the seats being the driver's seat, I would only need 3 vehicles. If my drivers are not H-2A drivers, I would need 4 because all 3 of the driver's seats would be occupied by someone that's not an H-2A worker, which means I wouldn't have enough seats to accommodate all my H-2A workers, which answers that next question as well. What requirements do I need to meet for transportation? One of the requirements that you need to meet you need to make sure that your vehicles are safe. You should get your vehicles inspected. There is a form issued by the Department of Labor that I'm happy to send out that you can get all your vehicles inspected on. Department of Labor comes and audits you. If you're not a farm labor contractor and they come and audit you and you have your vehicles inspected on these forms, they're going to be very impressed because most people fail to do that. But if you get it inspected, that'll be perfect. And you're supposed to annually. So I'll be happy to send out that form here in a little bit. Can I do back-to-back trips for transporting workers? Yes. So that's one way to get around the whole if I don't have enough vehicles issue. Will the distance from job site affect transportation? Absolutely it does. Yeah, that you can only travel so far, that otherwise Department of Labor will say your housing or your work sites are not within reasonable commuting distance, and it's a violation of the area of intended employment issue, and you need to file multiple applications. So distance is very important, so pay a lot of attention to that as well. I believe that is all the slides too. Okay, so let me stop sharing here. Oh. How do I get out of this? There we go. Then we'll come over here and we will start to move into Q&A. Okay, so here we go. So this question is, what about cleaning fees of apartments? Can we deduct workers staying in that apartment? No, nope, you can't. I mean, you can ask that your workers maintain a clean apartment, but if you choose to have someone else come in and clean it, you can't deduct the cost of that from their paychecks. And then this next question is, okay, well, what about if they damage tools assigned to teams? So you would still have to, this is referring to deductions as well. If you're wanting to deduct damage to tools assigned to teams, it can't be ordinary wear and tear. So if I assign this team this hammer and that hammer is 3 years old and it breaks, Department of Labor will say, yeah, hammers break after 3 years. Now, if they do something stupid like they run over a saw, in that case, you could deduct it so long as so long as it's disclosed on the job order and you're able to deduct it from the responsible party. So, so this one is, oh, sorry. Yeah. So this question was, can we deduct water and electric bills from the workers' checks? The answer is no. You cannot deduct water and electric from the workers' checks. Thank you for that question. Let's see. Now that TDHCA is enforcing their migrant housing laws, I was told that although I have 3 individual houses for 3 workers, this is considered one facility and subject to license regulations of $250 a year. This is a great burden to our small ranches. Is there any hope of changing that definition? I mean, I don't see any hope. I don't think that the Department of Labor or the state workforce agencies are trying to make it easier to use H-2A. I think they're actually trying to curb the usage of it, and they're making it more and more difficult to use it. I do think that this is deliberate. And so, no, I wouldn't hold out hope for them making it easier on you, at least for the next few years. This is a great question. So do the apartments have to have laundry facilities, or can they use laundry mats? They don't have to have laundry facilities, but if they have to go somewhere to have their laundry, to do their laundry, say in their off times, the employer is required to pay for that. That's something that a lot of employers do not know. But Department of Labor will fine you back wages for that if the workers are having to pay for their own laundry. And the other thing is you need to make sure to give your workers enough time to do their laundry. So you can't give them just one day every 3 weeks. You'd want to make sure they can do their laundry every week and continue to have clean clothes. If you get your vehicles inspected, who should do and document the inspection? I would say just take it to any third-party mechanic. It should not be anyone within your entity that is doing the inspection. It needs to be an independent third party. But the housing inspection or the vehicle inspections are pretty straightforward, and you could take it to any mechanic or vehicle inspector, and they could do it. If a worker has a valid CDL, does that allow them to drive regular vehicles such as a pickup truck to drive to work? Yeah, they can. Yeah, their CDL will make it work. It's a valid driver's license either way. With transportation, if we pick them up and transport them in a vehicle to and from work and grocery store, is that adequate, or do they need their own vehicle? No, that's adequate. Yeah, so pick them up, take them to the grocery store, take them to work. That's good. They don't have to have their own vehicle. They just have to have transportation. Thank you for that clarification. Okay, we have one housing site without kitchen facilities, which we implemented due to COVID. The crew has told us that they only want 2 meals a day. We have them sign a sign-up sheet daily for the next day to document this. We are also only deducting 1/3 of the daily allowance for each meal to reflect this. Is this an audit risk? So it is an audit risk because the regulations specifically require you to, this is something that is very frustrating, but the regulations specifically require you to provide 3 meals a day. And that's not something that's waivable by the workers. The regulations in general are not waivable by the workers. So, this is something that comes up pretty regularly, especially under the Fair Labor Standards Act, which all H-2A audits also encompass the Fair Labor Standards Act, Migrant Seasonal Protection Act, and the H-2A regulations. And the Fair Labor Standards Act is not waivable by the workers, neither are the H-2A regulations. And this comes up all the time in these audits. So one place where you see this all the time is, let's say that I own a restaurant and I've got my nephew works there, and he works his butt off, He loves working there and supporting our family. Department of Labor comes in and does an audit, and they realize that my nephew was willfully, without complaint, working for less than the minimum wage. He didn't even know it, actually. He just got tips, but he was working for less than minimum wage. My nephew could say, I don't want them to have to just pay me more. I don't want to put the business in a bad situation. Department of Labor says, I don't care. They're going to pay you more because that's the rules under the Fair Labor Standards Act. So what's the proper way to keep notes or proof of deductions to workers? So this is a requirement under 20 CFR 655 122 K. You have to provide timesheets to your workers under that section. And one of the requirements, so the timesheets need to provide on or before each pay period. And one of the items listed on those timesheets is the deductions that you take from your workers' pay. And the other thing to know about these is they don't have to be provided on the same form, because your general QuickBooks pay stub wouldn't have all the requirements in there. So it might be some other report that you generate with it and then just attach their pay stubs, but you don't have to provide them on the same document. You just need to give them the documentation under 20 CFR 655 122K on or before each pay period, and the deductions are part of that. And then also, whenever you are deducting, let's say that you're deducting some damage or something like that from your workers' pay, one, document how you know it was them. This wouldn't be something that you put on their pay stubs, you put it in an employee file, but document how you know it was them, the damage it cost, the receipt for getting the damage repaired. And then also always make sure that the deduction does not then violate the Fair Labor Standards Act. So where that can happen is, let's say I have a worker who was driving one of my vans and they hit a deer and it caused $1,500 in damage. Their paycheck was going to be $1,500. So sorry, you're not getting a paycheck this pay period. Well, the deduction cannot ever put them below the federal minimum wage for that work period. So what you have to do on occasion, whenever it's a significant deduction, is deduct it over multiple pay periods to not violate federal or state minimum wage laws. Okay, what if they get pulled over driving a company vehicle and they receive a citation? Are they responsible for paying for it? Yeah, yes, they are. This one said they missed the answer regarding, can one of the workers be a driver? Yes, they can. If you're a farm labor contractor, that driver needs to get an FLCE. It's advisable that any person you have transporting these workers also have, even if you're not a farm labor contractor, they do have the doctors, the medical inspection, which we can also send you as well. And they need to have a valid driver's license. They need to be insured. They need to be paid for their drive time, but they can drive. This one was, do you have a sample on the appropriate way to write it in the 790 about the cost of the damage? Yeah, I mean, if you're one of our clients, it's in your 790 because we put it in all of our clients' 790s. If a worker destroys something in the house due to a fight, can we deduct the replacement cost from the worker if it states it out? If it states it in out rules of residency agreement we have with the man, even though it's not on the work order. So I think in this situation, there was a fight between workers and there's a residency agreement between the workers and the employer, but it's not disclosed on the job order. Can you deduct the cost of the damage? The answer is not lawfully. Okay, so this is a great question. What if the workers themselves hire a cleaning service and request we do payroll deductions to ensure payment on time? However, the contract is between them and the cleaning service. I would tell them to pay the cleaning service directly, and for y'all not to do the payroll deduction, just because the payroll deduction, this is how the Department of Labor investigates. They come in and they ask for all the payroll data, all the pay stubs, and they'll look at the deductions, and then they'll ask about it. I think that that's very defendable in an audit, but it would prompt a question, definitely prompt an unnecessary question where you wouldn't need to be involved in an audit. But to answer your question in short, I think it's very defendable to say no. I mean, technically, the Department of Labor could say, well, that wasn't a lawful deduction, but that would be there would be an unjust enrichment argument beyond that. So I think that there's a way to argue that one for sure. But I would suggest that you do have them pay it directly. Okay. I'm loving all these questions. This is fun. This is H-2A land. This is good. If we were to have a here we go. If we were to have a temporary house, a worker in a location without a full kitchen facility, could the meals provided to the worker be a meal provided by another worker? For example, in a quarantine situation where a worker may need to be quarantined in order to, in another portion of the house, they have a private bedroom, bath, but no kitchen. The other guys in the house prepare meals, leave them outside the doors. That yeah, I don't think DOL would have any issue with that. I mean, that's with COVID, there's a lot of uncertainty, I guess. Would the Department of Labor complain about the workers not being licensed cooks and preparing a meal for the other worker? I don't think so. That would be very unreasonable. So I would say that that's fine. And if the Department of Labor fought you on that, I would be pretty shocked. They're not crazy unreasonable. The vast majority of inspectors are rational human beings, so they would I think be just fine with that. Are they able to get driver's licenses, and how long might that take? They are able to get driver's licenses here in the United States. It's going to depend on your state specific laws with in terms of how long it'll take. Do they have to take a driving test? Do they have to take the written exam? Those sorts of things. But they can definitely get driver's licenses here in the United States. They also need to get their social security number, which can usually be the cause for delay. That is one thing. Make sure when your workers get here, if they don't have a social security number, get their social security number. You don't want to have they're not even subject to social security tax, but you do want to get their social security number because you can be subject to significant fines by the IRS if you don't. Do we have to pay overtime to the workers after 40 hours? That's going to depend on where you are. So, and actually the type of work that you do. So whenever you're thinking about overtime with H-2A, it's based off of the Fair Labor Standards Act. You can qualify for H-2A a few ways. One, you can qualify for H-2A based off the definition of agriculture under the Internal Revenue Code. The definition of agriculture under the Internal Revenue Code does not have an exemption for overtime, whereas it does under FLSA, which is how the vast majority of people qualify for H-2A under FLSA. So that would be one thing. How did you qualify for H-2A? Was it based off of IRC or FLSA? Vast majority is FLSA. So let's say that you fall in the vast majority of applicants that are that qualify under FLSA. Then on a federal level, you are not subjected to overtime. However, that is subject to state laws. So there are a number of states that have overtime requirements, and it varies based off of when those overtime requirements kick in. So California, for example, has overtime requirements for H-2A workers or agricultural workers. Minnesota does after 48 hours. The state of Illinois does for agricultural construction because they specifically excluded, well, I guess when it's done by not a farmer. So you have to provide overtime in Illinois under those circumstances. So it depends a lot on the state laws, but as a matter of federal law, if you qualify under FLSA, you're not subjected to overtime. But you'd have to tell me more specifics about your the state where you're working and the type of work you're performing. Most states, so Illinois with construction is the anomaly. Most states just adopt the definition of agriculture under FLSA, and then they'll just say something like, but still, agriculture overtime over 48 hours is basically how they normally do that. If a worker has family in the area and wants to stay with them and the house instead of our approved housing, can we have them sign a waiver of some sort? No, because the regulations require that they stay in certified housing. You could get their family's housing inspected though, and then it would be fine. Well, yeah, it would, yeah, it'd be a lot easier to argue that. It's technically employer provided housing, so I guess maybe they would want employer to contribute towards housing in some way, but the big thing there is that employees not paying for housing. So if workers are being transported to place of work, do they need to be paid for transportation time? The workers themselves, no. The driver, yes. Unless you have, so if they're going from the housing to the work site, no. If they're going from the housing to your, let's say they're going to the farm, and then they have to go from the farm to another farm. So they get started at one farm and go pick up some materials or whatever, and then go to another farm. The time it would be from when their workday starts, which would be when they got to the farm in the first place. Okay. Let's see. In regards to the medical exam for FLCE, is it required to be signed by an MD? Past practice was having chiropractors sign the examination, but I believe that's changed. Yeah, so they are requiring, I think they're allowing PAs to now. That might have happened just last year, but MDs or DOs are definitely, which are medical doctors, not chiropractors or otherwise. So MDs, DOs, your safe bet. I think they're allowing PAs to at this point. And that is something that the FLC office actually checks, is on the inspection who signed it. Okay, if you have 12 H-2A workers in the house and have only one bathroom, can you provide a porta potty as a backup bathroom? I mean, you could, but a porta potty wouldn't meet any of the requirements. But I think if you have 12 H-2A workers in a house and only one bathroom, that's actually permissible. That's the maximum amount. But a porta potty in of itself doesn't really do much for you because it wouldn't pass DOL standards. So this is an interesting question. My workers have requested Wi-Fi and cable service. Who pays for that? It's easily $90 a month per housing location. I have a total of 5 housing locations. So I would just have the workers themselves set it up and pay for it if that's something that they want. I wouldn't deduct the cost of it, but there's no problem in having them set that up themselves and paying for it themselves. They're requesting a letter as to why they need a social security card in order to make an appointment. Could you provide us with that letter? Sure. Yeah. Yeah. I mean, that's easy. The Social Security Administration and the Internal Revenue Service have specifically stated that it's a requirement. So pretty easy to cite back to that, but I'll be happy to. Just email me afterwards. If we're moving our ranch to a different location, city, who all do we need to notify if we're moving our ranch? Who all? Are you sorry, I'm not sure if this thing, if we're moving our ranch to a different city location, or if they meant to say we're moving our housing from our ranch to our different city location. So if the workers are going to a different work site, so let's say that you bought another ranch in a different location, you would need to file a new certification to transfer them onto that application. Now, if you are just looking to change the location and the housing, that's going to be a new certification as well. If you're looking to just change housing, you'd have to notify the Department of Labor in the first place, and then the state workforce agency, of the need for the housing change and why it's not your fault and it's not foreseeable by you. Otherwise, Department of Labor is going to just make you go through the application process and transfer the workers to the new application. Okay, about the ability to pay overtime to workers. They're in Arkansas and they build livestock confinements. So Arkansas does not have overtime requirements for H-2A, and that includes agricultural construction. Thank you guys for all these questions. I really appreciate this. If a worker from the past season who was not picked to come back for next season starts to harass you, what can be done here? I guess it depends on how they're harassing you. If they're outside of the United States, there's not really much to do other than ignore them. But yeah, no, there's not really a whole lot to do there. I guess you could always report them to the police if it's something that scares you. But if they're outside of the United States, then there's not going to be much that the local law enforcement will be able to do about it. Okay, so what about this one? What can be done if an employee refuses to maintain their housing as far as cleaning? I guess it would depend on to what extent. Are they causing damage as a result of their inability to maintain a clean house? If they are, can you document that damage? And then you could foreseeably, if it's disclosed on your job order, deduct the cost of the repair caused by their lack of cleanliness. That would be basically the extent of it. And then you could always, based off of your job order and your ability to terminate workers, you could potentially fire them and replace them if they're not abiding by the job order. So that would be a good thing to check, is your job order, rationale for termination, and then also, if they're causing damage, is this something you can document and have repaired? So, okay, awesome. Do we have any other questions? So this one is, if we're based out of Iowa and we have workers work in Illinois, does that mean that we have to pay them overtime? So if you are performing agricultural construction in Illinois, yes. This is actually this is a very interesting question, because the rationale for paying overtime is not based off of where you're based out of or where the workers are housed. It's based off of where the work is being performed. So if you're in Iowa, for example, and you do work in Illinois and Minnesota, you would have to abide by Illinois and Minnesota overtime regulations as it relates to agricultural. I guess Illinois is just ag work, but or in Illinois it's ag construction, in Minnesota it's any ag work. So yeah, you would. What other questions you got? Okay, well, we can wrap this thing up. Oh, here we go. Can you clarify the withholdings from H-2A workers' paychecks in regards to taxes? Yeah, so H-2A workers are not subject to FICA taxes. So that's Social Security, Medicare, Medicaid, I think. But we can email out information on the deduction of housing, of taxes from workers' paychecks. So let's see here. The things that we're going to email out after this one will be tax documents. We'll email out the OSHA housing checklist. We'll email out the vehicle inspection form. And then we'll email out the medical inspection form. Okay. So be looking for some documents to come in your email after this one as well. Oh, we got a few more here. So this one, okay. Yes, I will. I'll add you to the emails, and then yes, email me after. So this one was about the Social Security letter. Email me afterwards, so I can have your information specifically, and then I'll email you a letter. And then this one was the fight question. Or did I scroll up? Yeah, this is the fight question. So the fight question was: workers in housing got in fight, caused damage, violation of a residency agreement between employer and employee, but not disclosed on job order. Then you can't deduct the cost of it. It needs to be disclosed on the job order. Sure. So this is it legal? So this question, and just so everyone knows, it's totally fine if you ask questions that are off topic. I'm happy to answer any H-2A related questions or otherwise. So is it legal to have an H-2A worker pay for his visa and his ticket? I know it's not the topic today. Okay, yeah. So is it legal for an H-2A worker to pay his visa and his ticket? So this is employers are required to reimburse workers for the cost of their visa and their inbound transportation once they completed 50% of the work contract. But this is still subject to the Fair Labor Standards Act. So it depends on where your worker is coming from. Let's say that your worker is coming from South Africa. And as a matter of practice, we always just have our clients pay for inbound transportation and visas at the very beginning, because it avoids a lot of problems with the Department of Labor. And it's just not worth the headache. I mean, the replacement rate on these people is so low, and most of our workers come from Mexico. Now we have a handful that come from South Africa, but mostly from Mexico and several other countries. But so the question is it legal to have an H-2A worker pay for his visa and his ticket? Technically, yes, at the beginning, but once he completes 50% of the work contract, you have to reimburse him for that ticket. The other thing is that this is still subject to the Fair Labor Standards Act. And so if you have a worker that's coming from South Africa, for example, and their first paycheck would be $1,200, but the cost of their plane ticket and the cost of their visa adds up to $1,200, that would mean that they made actually $0 on their first check, because the DOL factors that in when they're looking at their first check. So in that circumstance, you would actually have to pay your workers back on their first paycheck, because otherwise you'd be in violation of the Fair Labor Standards Act. Okay, if they damage washer and dryer in the housing, do we need to replace it? Yes, and you can deduct the cost of that if they did it through negligence. If it's ordinary wear and tear, you can't, but even if it was through negligence, it needs to be disclosed on the job order. What's allowed as far as entering the house to inspect? This is a great question. I'm not actually sure. Yeah, that's a good question that I actually haven't been asked before. So I'm gonna actually have to look into that one a little bit. Okay, I'll look into that one, and we'll get to that question on the next webinar. Ayana, do you mind writing that down too, please? Do all the workers that drive any of our vehicles need the medical card along with their license? I highly recommend it. So anyone that drives or transport migrant workers, I say get the medical inspection for them. Anyone that drives or transports migrant workers. So whether, and if they're driving themselves, that would be included. So I would get that inspection for anyone that gets behind your vehicle. So this question, so they do not get reimbursed upon arrival. It depends. It as a practice for our clients, they reimburse upon arrival. Under the H-2A regulations specifically, you don't technically have to until they complete 50% of the work contract. unless it violates the Fair Labor Standards Act. So it's going to depend on where your workers are coming from, the cost of their inbound transportation, and the amount that they would get paid on their first paychecks. So it's in our contract, the workers must have steel-toe boots, most of them wait until they get here to purchase the boots, and then payroll deduct. It's written in the contract, they must have steel-toe boots. Is the payroll deduction okay for this? So I believe that is specifically written in your work contract, so it would be fine. I need to review the exact language. This question was from a client of ours, so I'll have to review your specific language, but I believe that that's fine because I think it's written in the work contract to be like that. If not, I would have them purchase their own boots, or we can try to write it in the work contract on the next one. Okie doke. What else we got? Okay. All right. Well, I appreciate all the questions. Those are definitely helpful. The Q&A is always the fun part for me. So again, we'll be doing another one of these here, I guess, I don't know, next week, week after next, whatever Ayana tells me. But I certainly look forward to it, and I appreciate the time that you spent with us and all the questions that you asked. It's really helpful for us. Oh, two more. All right. I want to make sure I understand this driver conversation. We are farmers. We provide a transport vehicle, but the workers drive the vehicle with a valid driver's license and therefore transport other workers. Do I understand you that you are saying the situation, all drivers should have a medical card? Yes, I would have all of those workers get the medical inspection done. And then this one was, can I share the responses to the questions that we were asked in case they missed something? Yeah, all of these webinars are recorded and they're all posted on our website afterwards. So feel free to watch this as many more times as you want. And if there are any costs associated with the medical card, are we responsible for that? Yes. Though it should be pretty minimal. I don't think it's substantial at all. The medical inspection is very basic. I mean, it's a one-page document, very straightforward. Okay, well, I certainly appreciate everyone. We will we'll get together on a webinar here soon, and I appreciate everyone's involvement. Talk to you later.